Mr. Green has specialized in the Texas workers' compensation insurance defense for more than 17 years. He travels to every field office in the state of Texas. He's a member of the workers' comp section of the Texas State Bar, has regularly spoken at the Texas State Bar Advanced Workers' Comp Seminar, and is authorized by the Texas Department of Insurance to present certified continuing education courses. And yes, this is a done deal, y'all, so we're good on this. Ricky is a member of the Texas Chapter of Public Risk Management Association, Prima, the Austin Black Lawyers Association, and the Travis County Bar Association. In addition to his legal commitments, Ricky serves on the Board of Trustees at St. Stephen's Episcopal School in Austin and enjoys traveling, running, and is an avid sports enthusiast. Yay! Yay! We're going to be at Texas Prima this year because we're having a football team, right?
Yes.
All right. Well,
Okay, don't go past there. You have to stay over here.
Oh.
Perfect. Thank you. Yeah, well, because I can't see you past there. Like where Donna was, I couldn't see her. You're good there.
Right here. Okay.
Yes.
Right in front of the screen, you're golden.
All right, right here. Right over here. You gotta get used to this right here. Can everybody hear me?
Yes, sir.
All right, fantastic. You're in the back. You hear me, right? All right. All right, everybody. Hi, my name is Ricky Green, and I'm an attorney. Been doing workers' comp for quite some time, about 18 years. Do a lot of work for a lot of public entities throughout the state of Texas. I got involved in workers' comp back in 1994, just after the new law became the new law, which is now we got new laws and newer laws, and we got new laws always coming about all the time, don't we?
Yes, sir.
For sure. So anyway, I'm excited to practice workers' comp. When I started doing workers' comp, it was just such an odd type of practice coming from where I came from. For those that have been doing workers' comp for a long time and have gone to hearings, everybody knows about bros, hoes, and dodos. We have a bro, which is a benefit review officer. We have a hearing officer, which is, of course, exactly. And we have what used to be called they've changed the name so many times, the disability determination officer. We used to call those dodos. But now they call them dispute resolution officers. I think they call them CSOs now, customer service officers. They've changed that name so many times. So when I started practicing workers' comp, it was, I thought that it was going to be one of those formal type of practices like anything else, and you would basically have to stand up and address the court and say, yes, sir, may it please the court. And now, I mean, everybody knows, I don't know if y'all know Johnny Goodwin. He's a benefit review officer in Dallas. He's passed, passed a few years ago, but Johnny used to always love to dip when he was at a hearing. He'd have a big old dip in his mouth. And he would have a big old cup right next to him. And I walked into my first BRC with Johnny, and Johnny had a big old dip in his mouth, and he was spitting. And I stood up and said, Smith, please the court. He's back. He's spit his little spit cup and says, son, sit on down. And I said, okay. And I said, well, here's my position. It was a really complicated hearing loss case. Probably one of the most complicated cases I've ever done. And I just started doing workers' comp. Literally walked into the attorney's office that I was working for. And he says, here's a file, go do justice. And I said, well, point me in the right direction, where do I go? And he says, well, go to the Dallas field office. And I said, okay, what's the directions? So I knew nothing about workers' comp at this point in time. Got this complicated hearing loss case, go to Johnny Goodwin's office. He's got a big old dip cup and a big old dip in his mouth, and he's spitting. And he says, well, what's your position? I said, I forgot. I don't know what it is now. What is my position? And I thought workers' comp was definitely a very interesting and very unique practice for sure. And so I worked. So this was back in 1994, and in 1996 I joined Harris & Harris, and I was at Harris & Harris from '96 to 2005 for 9 years, and then I've been on my own since 2005. So basically my 8th year, just past my 8th year, going to my 9th year right now. We do everything workers' comp. Hearings, State Office of Administrative Hearings as well, compliance, MDR, designated doctor, analysis letters, judicial review, subrogation. We do all that good stuff. So if anybody has any questions, please feel free to call me. I'm going to get out of this line of sight of this camera for a little bit right quick and hold up these wonderful green pens. I have a ton of them. If anybody wants them, just come up at any point in time and get them for sure at the end of the presentation. If anything, you will always remember me by these pens, because people will say, well, what's your name? I say, remember those green pens? Oh, yeah, you're that green guy. So, and then we got some business cards this year as well. So we got plenty of pens. Sign-in sheet. What is the scoop with that?
Sign in if you need CE.
Okay. So this is certified for 1 hour of continuing education. It's going around the room. I don't know who needs credit, but I'm assuming just about everybody in this room. Oh, maybe not. I don't know. Who needs credit? Just curious. Show of hands. Okay. So not a ton of people in here. So those that do not need credit, I'm just curious, what are y'all's professions generally?
They're all attorneys.
All attorneys? Oh my goodness gracious. Oh my goodness gracious. They're going to burn this place down. They got all these attorneys in one room, and this is like, it's going to be incendiary here.
Oh, I'm sorry, chiropractors.
Chiropractors. Okay. Well, even worse. Come on. They're going to really light this place up on fire then. Going to get rid of all of it at one shot here. All right. So anyway, it's great to be here at Prima, speaking to you guys again. If you have any questions at any point in time about our presentation, please call me, email me, whatever you need to do to get in contact with me so we can follow up on some of these concepts today. I'm going to first talk a little bit about legislative updates a little bit, what's going on in the legislature. A lot of people like to hear what's going on with that. There's not really a lot going on. I'm sure there's a lot of people in this room that may be in tune with what's going on. I'm just curious, has anybody been paying attention to what's going on with the legislature? Anything? Okay. All right. All right. So a few things that are going on. I mean, there's always these new bills that are popping up all over the place. As we all know, a lot of bills get filed, but a lot of them don't necessarily make it out of committee and become law and get signed by the governor. One of the newest bills that was filed was actually filed by a young lady out of Fort Worth named Wendy Davis. And this is a bill that says that a person is entitled to lifetime income benefits if their impairment rating is 85% or higher. And this is a new bill that was filed probably maybe a week or two ago, I guess, probably. In addition, that bill obviously supplements the current existing lifetime income benefits eligibility requirements. Of course, you loss of, you got burns, a certain degree of burns. You lose 2 arms, loss of function of 2 upper extremities, 2 lower extremities, an arm and a leg, at least 2 different body parts. And if you have a incurable imbecility or insanity is one of the standards as well. So those are kind of the standards. And then they've added this. What's interesting about this bill that was filed by Wendy Davis is it says that if a person has an 85% of impairment rating or higher under the 6th edition of the AMA guides, not the 4th edition, not the 5th edition, but the 6th. So that kind of gets me thinking, are we looking at possibly changing AMA guides and moving from the 4th? Because we're really far behind a lot of other states, as you probably will know. A lot of other states, I mean, they've been on the 6th edition for quite some time. A lot, 5th edition for sure. It's been a lot of states have been on the 5th for eons. So we're really still far behind on where we're at regarding the AMA guides. So it'll be interesting to see what happens with that. Other bills that have been filed that are really of interest to us is one, House Bill 1032, proposed by John Zerwas of Richmond. The bill will require a single standard form for requesting prior authorization of prescription drug benefits. This is something that's been filed. This is applied to everybody trying to get prescription drugs. Another one, this is a really interesting one, 1155. This bill would allow the insurance carrier to suspend any and all benefits if the claimant fails to attend the DD examination. So the current law is that you can only suspend TIPS. But this one is, if they miss a DD exam and the person is, for whatever reason, getting some other type of benefits, whatever it may be, especially SIF, because you can always request a DD to determine return to work after the second anniversary. And if they miss that and they're somehow getting SIFs at some point in time, you can suspend benefits. So this is a really interesting bill. We'll see if that passes or not. I doubt if it will, but we'll see if it passes or not. Another one that's been proposed is 1424. This bill allows a first responder to sue a state or local government entity for wrongful termination action. And this is interesting because this would kind of supersede. Well, it's going to be interesting to see how that plays in context with the Texas Tort Claims Act. I don't know how that's going to work, but it's been a bill that's been proposed for sure. Now here's another interesting bill, 1468. This bill is based on the XL Specialty Insurance Company case. Has anybody, are you guys familiar with the, okay, I see a shaky head, so one person in the back over here. Anybody familiar with the case that says that communication between the attorney and the employer is not confidential? That's the case that's out there. All right. That's the case that's sitting out there, and it's a huge case. Oops, sorry.
I thought it was between the attorney and, so TML, they have an attorney, I'm the employer. You know, my conversation with the attorney is not confidential. Is that what it is?
Correct.
Okay.
That's right.
Yeah.
Okay, so it's not between TML and
It's the attorney and the employer. It's not confidential.
Okay.
Correct.
See, I was in a workers' comp thing yesterday in Houston.
Mm-hmm.
Apparently I didn't learn very well. And they went over that, but they went over it so fast, it's like, I was in the back, kind of left me, not really sure exactly. So it's not between TML and the attorney, it's between me and the attorney that has the.
Now, what is your?
I do workers' comp for the city of Friendswood.
Oh, okay, okay.
And risk management.
Okay, okay. So, well, what this case provides, and basically what, let me give you a little bit of background about this case, is it was a case involving a private carrier, XL Specialty Insurance, and the workers' comp attorney. And what happened was it went to a CCH on compensability, whether the claimant was in the course scope of employment. I believe that was the issue. Anyway, it was determined that the claimant was injured in the course scope of employment. So it went to an appeals panel decision, I believe. The AP came back and says, rubber stamped, claimant in the course scope of employment. The claimant filed a bad faith lawsuit against the insurance company saying, you never should have denied my claim. Look, I won, you guys owe me money, breach of good faith and fair dealing, which is the term, the law term for bad faith is breach of good faith and fair dealing. The attorney representing the injured worker, I can't think of that, what's his name? I can't think of the injured worker's name, anyway, whatever it is, requested in discovery all communication between the workers' comp attorney, which is, it was a flay hive case, it's all, it was a flay hive case, and between the flay hive and between the employer, all right? Now, of course, communication between flay hive and the carrier is protected as confidential. Now, the court says you have to turn over all your emails between flay hive and the employer. At that point, the flay hive filed a writ of mandamus, went to the Texas Supreme Court, and the court was asked to determine the question of, does flay hive have to turn over all communication that it had with the employer? And is that protected under the attorney-client privilege? That's the question. So they went through this whole analysis, looking at all these legal cases, looking at these legal doctrines, and trying to determine if this is protected communication. One of the questions was, well, is the employer a party to the case? Because in Texas workers' comp, it's always framed the claimant versus the insurance carrier. It's not framed the claimant versus the employer. And so the employer is not a real interest a real party of interest. And in Texas workers' comp case, for those that are familiar with other states like Oklahoma, it's the employer that is the named party. In Texas, the workers' comp carrier, the insurance carrier is the named party, not the employer. So they looked at all these different concepts and they said, well, based on Texas laws, Texas employers are not in a protected class as far as communication is concerned, therefore that is not privileged. And therefore any communication between the workers' comp attorney and the employer is not protected. If they have to turn over all their emails. And that kind of chills our ability as the attorney to work closely with the employer to work up a case, because there may be a lot of strategy that I need to share with you, city you're friends with, in working up a case for a CCH or a trial or whatever it may be. And so what a lot of carriers have started doing is creating maybe some type of firewall and saying that any communication between me and the carrier goes in its confidential part, and then any communication between me and the employer will go to another part. And a lot of times the employers that used to have access to the whole claim file don't have access to that anymore, because that could be a breach of that attorney-client privilege and allow other people to get access to it if the employer has access to it as well. So that's been something that a lot of employers, are it's hard to deal with, because I know a lot of employers used to have access, and I don't know if you do or not, I don't know y'all's system here, but that's been somewhat of a chilling effect in the industry, for sure.
Ricky, can I ask you a quick question?
Absolutely.
But in a situation like, I'm sitting here, City of Boston, sitting right here, they are their own carrier because they're self-insured. So in reality, just as a TPA, we're just managing the claims part, but wouldn't they be protected because
I would agree with you on that.
Definition of a carrier, they are a carrier.
I would agree with you on that to a certain extent. And the exception that I would apply for that is if it's the City of Boston risk management department, absolutely. But if it's some other weird department, sanitation, going into your claim files, I don't think that's probably going to be protected, because I'm just purely speculating when I say that. Yeah. So I don't think that anybody that of the thousands of people that work for the City of Boston, all thousands are going to be able to have access, and it's going to be protected because they don't have any interest in a workers' comp claim, and to that effect. So that would be my guess. So, but generally, that a City of Boston would be their communication is protected for sure. If it's into risk management, I guarantee that.
Does the confidentiality extend to agents of the carrier, for instance?
And that's the question. What is an agent?
Would the insured be an agent if you went to the carrier and to get a question that you really wanted to go to the insured, but you went through the carrier because the carrier had communication with the insured, wouldn't the insured be an agent and fall under that line?
Well, there was, that's one of the arguments that was made by the attorneys for the mandamus action was, would the employer generally be considered an agent would the employer be considered an agent of the workers' comp carrier? That was one of the questions that they considered, and they said no. That you can't constitute that as an agency relationship for a number of reasons. They went through agency principles, and they were looking at legal definitions of what an agency relationship is, and they said no, you can't constitute that as an agency relationship for a number of reasons. But yeah, that was one of the ways that they tried to say, well, the employer would fall under the umbrella of the workers' comp carrier as an agent. And they said no, it would not. So it makes it kind of difficult. Now, one of the suggestions that I've been giving for employers generally is, if you want to have a confidential communication with me, then we got to do it by telephone. I'm not going to send you anything in writing discussing strategy and my pros and cons of the case, and don't send me anything in writing discussing the pros and cons of the case. And that as the current law stands. So we're just gonna have a phone conversation about it, to be honest with you. That's what I think is the best way to handle this. Now, there's a new bill that's introduced that says that any communication between the work comp attorney and the employer is confidential. That's the bill that's been filed.
Do you know what number it is?
Yes. It is House Bill 1468, and it's proposed by Kenneth Sheets of Dallas, Texas.
Thank you.
Sure, absolutely. And there's been a couple other bills that have been proposed, but nothing of real significance that I believe is we need to really go and delve into detail. Texas Mutual wants to cut ties to the Texas government. Basically, they want to be able to do their own thing. I'm not even worried about that one. So, yeah. So that's kind of the bills that have been proposed, and I think this bill regarding the communication part, I'm hoping that it passes, and I really do hope it passes because I think we really need to. It's really chilled us in the workers' comp industry. I just can't. You know, the employers want to shoot me emails. I'm like, wait, hold on, no, delete. So we'll just see how that goes.
So how does this work for
Absolutely.
a municipality where I get a request from the city secretary that says, we have an open records request, you need to disseminate any and all information you have on X. Do I not have to give up information on our conversation?
So, okay, explain that one more
So
time.
I have an open records request.
From somebody.
From city secretary's office.
Okay, city secretary, okay.
And they say that because I'm municipal government,
Mhm.
all my records are open,
Mhm.
and except for workers' comp. And they say that, we have open records request for any and all information on this case. Now, a lot of that information I have up here, do I have to disseminate that information? Do I have to write that down, or
No.
since it's not on a written file, I'm fine?
Correct. Correct.
I'm gonna need a bigger hard drive.
So anybody have any input on that? What do y'all think? What do you think? Right,
Written only.
Yeah.
right.
Only what's in writing.
What'd you say?
Only what's in writing.
Right.
Of course, when you're audited, you're gonna have a problem if it's all
Yeah,
clear.
or when I'm subpoenaed and I'm sitting up in front of the judge and they.
And you have
ask
nothing to
questions.
back up anything that you have. I
Yeah.
mean,
I hope, you're right, I hope that passes.
Oh, yeah, absolutely.
Get that written.
And then everybody,
Has it been
again,
heard in committee?
what's that?
Has it been heard in committee?
I don't know. You mean has it been enrolled?
Yeah.
No, I don't know. I think I saw that it was filed. I don't think it's been enrolled. Let me see. Yeah, it was introduced. I need to follow up on that to see where's that in committee. I have no idea. If it even, I'm assuming it's been enrolled in committee. I don't know yet. For those that, for the legislative process, once the bill is introduced, and by the way, a bill can be introduced for any number of reasons. Mainly somebody gets really mad and says, I want this bill introduced. And so there were some wacky bills in the past. I remember one that said that if the claimant does not have an attorney, the carrier cannot have an attorney. And that came about because somebody got really mad at a BRC, a legislature got really mad at a BRC, and thought that the carrier's attorney was being the harshest butt, and says, well, I'm going to deal with this, then, and I introduced this bill. It was just craziness. So anyway, so once the bill is introduced, there are so many different committees because you can't have every bill heard by the full House and Senate. So they have these committees, and it's got to go through committee, and if sometimes things don't make it out of committee, sometimes they make it out of committee, and then they're read on the floor to the whole House and then Senate, and then at that point in time, it goes back to the committee, I believe, and then they make any type of amendments and alterations, I think it may goes back to the floor for final approval or something, and then it goes to the governor to either be approved or vetoed. And if the governor doesn't act on it within, I believe, 10 days, it becomes law automatically. So there's a process in how these bills are handled by the Texas legislature. So. All right, and again, if y'all have any questions about anything, please ask. A lot of times we get a lot more out of this if y'all ask questions, because these are just PowerPoint slides. And just think of me as kind of a moderator, not necessarily as a speaker that's trying to speak to you, but you may have great suggestions, ideas that you want to share with everybody else that's more meaningful to you than going over through some PowerPoint slides. So if you have any questions, please ask at any point in time. We'll just share some ideas. All right. In this case, the Atkins case, this is a SORM case that came out in 2011. Atkins was involved in a car wreck on October 25, 2005. Can y'all see the slides here? Is it too much too light? Y'all want it darker? Okay.
I'll let you hear snoring.
So he was involved in a car wreck October 25, 2005. MRI shows multi-level disc bulging. He claimed a work injury on October 11, 2006, so a little bit later he had a work injury. First a car wreck, then a work injury. He quickly turned his head and felt a pop in his neck during the work injury. He was diagnosed with herniated disc at C5-6. A jury determined that Atkins suffered a compensable injury in 2006. On appeal, SORM argued that Atkins could not meet his burden of proof because he did not provide expert testimony regarding causation. The court determined that expert medical testimony was needed because lay persons do not have the knowledge to understand the intricacies involved in diagnosing a back injury without guidance of a medical expert. So what this case is basically touching on is the ideal of needing an expert to explain causation. And it's a little bit of background. When he was involved in a car wreck in 2005, the MRI showed multi-level disc bulging, and it also showed some degenerative changes. There was some disc desiccation. There was I believe there was I think there was spondylolisthesis as well that was noted in the 2005 MRI. So when he was at work in 2006, he heard a noise and he just turned and he felt a pop. So he says, oh, whoa, all my problems result from turning and trying to see what was going on. And we all know those type of injuries, right? The person is perfectly fine, never had a problem in their whole life, and then all of a sudden they reach down to pick up a sheet of paper and their back goes out and just their whole life is ended because of that incident. Well, this is one of those situations. And then so again, it went to a CCH, background, went to a CCH, the hearing officer says, not in the course scope of employment. Went to the appeals panel, rubber stamp says, not in the course scope of employment. The claimant filed for judicial review. The jury came back and says, hey, you got hurt in the course scope of employment. So, and then at that point in time, SORM appealed to the Court of Appeals in Dallas, and they went through this legal analysis. The legal analysis was, can you hand a jury a ton of medical records without an expert telling you what these medical records mean and explaining how turning and feeling a pop in your neck after you had significant injuries just within the past year, can you just hand all these medicals to a jury and say, hey jury, it's all in your hands, you don't need a doctor, you guys go ahead and make that decision, we don't need to provide an expert. And that was the issue that the Court of Appeals dealt with. Now the Court of Appeals basically stated in this particular case, they said, well, we have to look at other case law. And one of the big cases they looked at was the famous Gavada case. The Gavada case was a case that came down that talked about temporal relationship. And it talked about attenuation, meaning that if a injury comes up, well, actually, that's not what Gavada says. Gavada talks generally about that. City of Laredo talks about really more so about temporal relationship and attenuation. In the City of Laredo case, there was I think a person who worked for City of Laredo was throwing trash into a dumpster, I believe, and then had an injury, and then later developed something else. And the question was, you know, do you need an expert to explain why something did not develop until 2 or 3 or 4 months later when it did show up initially at the initial examination? So that's attenuation. So when you heard the word attenuation, that simply means something popped up later and didn't happen immediately on the first examination, basically. And this court explored those concepts under City of Laredo in the Gavada case, and they says that the court determined that the plaintiff or the injured employee must have a doctor to explain to common lay people, the jury, that are not doctors, that a person can develop all these issues from turning and trying to see what's going on beside them. And it's just common sense that you're going to need a doctor to explain that. But the old law used to be that you didn't need an expert to explain any of that. You could just simply have a person, a jury, look at attenuating causation and make a jury determination without a medical expert. So, but they said now you do. So if you go to a CCH, for all those that go to CCHs and that are involved in dispute resolution, if the claimant doesn't have a medical expert on these type of situations where there's attenuation or there's a complex type of injury, such as, you know, I think turning this way when the person has had the same or similar problems within the past year, they're going to need a doctor to explain that. And the hearing officers have been really good in Texas in saying that the claimant loses every time if they don't have an expert to explain causation in these type of situations. So it's been really good in Texas lately, for sure. Yes, sir.
And that expert has to base that diagnosis off scientific fact, not his opinion?
And that's a good question. What's scientific and what's his opinion is all kind of, you know, maybe interrelated to a certain extent. The doctor has to explain in reasonable medical probability what their opinion is. Now, they don't have to use the magic term reasonable medical probability, but they normally will, because that's a term of art in the medical community, to say that, in my opinion, and based on these circumstances, and they don't have to cite medical studies. They don't have to do anything like
They
that.
can just say that, you know, it's plausible that X caused the injury.
Correct.
Not, I know that X caused the injury. As long as
Correct.
you can get the doctor to believe it, we have.
Right. Now, what they will have to do is they're going to have to look, first, discuss the mechanism of injury, They're going to have to look at the old medical records, for instance, like in this one, compare it to the new medical records, explain based on each diagnosis, you know, why is this diagnosis that occurred based on a work injury, how is that different from the old diagnosis for the car wreck? So they have to show that there's some type of, now remember the definition of injury is damage or harm to the physical structure of the body. So they have to explain why there's new additional damage or harm to the physical structure of the body to constitute a new injury, as compared to it being a continuation of the old injury.
Could it be an aggravation of the old injury?
They could have to explain why there's an aggravation. Now, before, doctors could just vaguely use the word, well, there's an aggravation, and they didn't have to explain anything. But now they have to explain why there's an aggravation. An aggravation is a worsening, enhancement, or acceleration of the underlying condition, as compared to a continuation, which is just a mere exacerbation of the old injury. So they have to explain why there's a worsening of the underlying condition. And my argument, legal argument, has always been, well, doctor, you know, I'll say, okay, let's look at these medical reports. This doctor doesn't explain how there's new damage or harm to the physical structure of the body. If you look at C5, C6 from the old MRI compared to the C5, C6 for the new MRI, they're exactly the same. They're the same, you know, millimeters of bulging or protrusion or herniation. There's been no change in the condition. And I'll argue that there's been a mere subjective increase in pain, but you can't objectively measure and verify that there's been new damage or harm to the physical structure of the body. So I will make that argument all day long. And hearing officers will go with that a lot of times, especially based on the Bravada and Singular Radio cases, for sure. So, anybody have any other questions about that? Okay. Just curious, who in this room has, well, first, who goes to CCHs and BRCs in the room? Anybody? Oh, a lot of people.
Not very often.
What's that?
So not very often.
Not very often. Okay, that's good. You don't want to go to a lot of hearings. You don't want a lot of hearings.
No, only one.
Does anybody have a similar type of case right now? No? Okay. So if you do, and you have any questions about it, feel free to call me anytime. We can talk about it for sure.
And could I catch it while I'm at work?
Okay, the Gerald's case. I'm going to move through this kind of quickly. In this case, this is a 2012 case. Gerald's and 2 employees were injured in a car wreck. They were returning to work from a restaurant where they ate lunch. So this is a lunchtime case. They lived in Houston and worked at a tank farm outside of Jal, New Mexico. Their job was going to last between 3 and 6 months. They were required to use a company truck in Jal. They were not allowed to bring their own personal vehicles. Each day they commuted from their hotel to the tank farm. They ate lunch each day at a restaurant 2 miles away from the tank farm. During their rides to and from the restaurant, they engaged in personal and work-related discussions. Now, in this particular case, a little bit more background. They went to eat. While they were at the restaurant, they were making personal phone calls. They were calling their significant others, friends. They were also talking about business also. When they left the restaurant, they got on the highway and boom, an 18-wheeler hit them. As soon as they got on the highway. So it was a very devastating car wreck when they got hit by this 18-wheeler. So it went to BRCs and CCHs, and I can't remember exactly what the hearing officer found and what the appeals panel found, but it went to judicial review. So all 3 people that got hurt, each, oh, you know what? I think they lost, if I'm not mistaken. But anyway, all 3 claimants went to judicial review. There were 3 different cases that were filed for judicial review in regular court. There was a motion to consolidate, and 2 of the cases got consolidated together, and 1 was still left out by itself. Now, what is interesting is on both cases, Texas Mutual was involved in the case. Texas Mutual and the 3 injured employees all filed for summary judgment. So this is how twisted it can be when you go to regular court, okay? So you got one case over here, there's 2 claimants in a consolidated case. You got one case over here, a claimant is out by himself, right? So the 2 consolidated cases, Texas Mutual and the claimants filed cross motions for summary judgment against each other. The court found in the 2 cases regarding the 2 claimants that Texas Mutual wins. Texas Mutual gets the case thrown out of court, and they said that under the, I believe it was under the lunchtime case or coming and going or something like that, I can't remember the doctrine, they found that Texas Mutual wins in this one. This other case over here, claimants by himself, they filed cross motions for summary judgment over here also. They found in this court, the claimant wins, not Texas Mutual. So, same facts, they're all 3 in the same car, they all 3 go to the same restaurant, so court finds over here, claimant wins, court finds over here, Texas Mutual wins. So weird, cannot explain that. So, so that's kind of the procedural history behind these cases. So the case goes up to the Court of Appeals in Houston. The Court of Appeals looks at different legal doctrines. One, they look at the coming and going rule. Now, that's really interesting. Okay, are y'all familiar with the coming and going rule? Y'all heard about that?
Yeah.
Okay. Going to work, come in and going to work, home to work, all that good stuff, you're not covered because everybody is subject to, you know, if you're on the road and going to work, coming on, you're not protected, you're not in court scope of employment. All right. Now, there's another doctrine called the dual purpose doctrine. The dual purpose doctrine is if you are basically going from, and this is how the case talked, it was another case that came down, God, what's the name of that case? It was here in Austin. You remember that case? What is her name? She was going from, I think, a dinner, and she got involved in a car wreck on 360.
Sales rep.
Yeah, sales rep. Yeah. So that case talked about the dual purpose doctrine, that if you're going basically from a business meeting to another business site, that would be a kind of discussion of the dual purpose doctrine. And if you're going from home to work or work to home, that's the coming and going rule. So this case discussed those two doctrines. Now, generally, again, the coming and going rule is, you know, if you're going from, you know, home to work, you're not in court scope of employment. But of course, for those that are familiar with these concepts, you have to combine those concepts with the ingress and the egress doctrine, which is also called the access doctrine, which is once you step onto property owned by the employer, then you are in the court scope of employment. If you're in a parking lot that's exclusively owned by the employer and you slip and fall, you're in the court scope of employment. But it's always kind of interesting, you know, when you go from not in the course, and when you take that step onto the parking lot, when you go into the court scope of employment. You know, if you're on a sidewalk, and the sidewalk is on the property of, you know, Texas Municipal League, and they get hurt and slip and fall, that's going to be the court scope of employment generally. It's always interesting dealing with these cases where a person has to park in a parking lot far away, and they have to walk from a parking lot way far away, and they slip and fall. They may be a quarter of a mile away from the business premises. You know, is that in the court scope of employment? I mean, all these access doctrine cases and egress cases are fact specific, which make these cases very interesting. But in this particular case, they talked about the fact that generally, if you are discussing some type of work, you know, and you're doing something personal, that's a dual purpose doctrine. You got two purposes: it's work purpose and a personal purpose. And generally, they're going to find, in this case, they said that nobody's going to win on summary judgment because there's fact issues that need to go to a jury to determine whether or not the dual purpose doctrine applies and makes it compensable or not compensable. So it was a really interesting case here. It just talked about a lot of legal concepts, which I thought was really fascinating in this particular case. Does anybody have any crazy coming and going situations that y'all dealing with, or any access doctrine cases?
We had a case where a dispatcher was asked by her supervisor, dispatcher was going to go home for lunch, was asked, well, on your way home, would you swing by the dry cleaners and pick up my uniforms? So she said, okay. She swung by and picked up the supervisor's uniforms, went to go back on her route to go home for lunch, and she was in an accident. And we ended up paying off on it. Because my supervisor asked me, and said, well, you weren't ordered to do anything. You were asked as a friend, not because she was a supervisor. She said, no, she's always my supervisor.
That's and they're going to win that case. They're going to win that case. I mean, that's a special mission. And so if the supervisor, whether they act in the capacity of supervisor, I mean, they're a supervisor, and they give instruction, they're going to say that's a special mission. Special instructions from the supervisor, they're going to win that case. So, I mean, and I was just dealing with the situation. I have a case that's in judicial review right now. It's a situation involving a person that, an employee, they were involved in a horrific accident. It was really bad, driving from Houston to Port Arthur. And this injured employee was driving a group of people, co-employees, to this work site from Houston to Port Arthur, but they did this every day. So the question was, when do they become in the course scope of employment when they're leaving Houston and they're driving to Port Arthur? And so we're gonna probably get to a jury trial on that. It's gonna be interesting to see how that happens. But I've been seeing a lot of cases expanding the scope, the area of the coming and going rule, and not necessarily when you get on the premises, especially when you're traveling long distances, and that becomes really tricky.
And I actually asked my employer, I'm on the training day today, I'm out of Houston. I left my house before 5 to get here on time.
Mhm.
So it's a little over 3 hours drive. So, I cover it when I leave my home. Normally when I go to work, I'm not covered
Right.
until I'm at work. But since I'm on a special mission to come up here to do training, I've been asked to attend. Now I'm driving from Houston, so am I covered by my employer's workers' comp while I'm on that trip?
Well, I mean, generally, I think that if you were making a one-time trip, generally, you're going to be covered a lot of that way. There's been some appeals panel decisions in case law that talks about jurisdiction. When you leave your county, that you may be covered the rest of the way from when you exit the county to the end of your destination. And I've seen some cases like that. Things turn so differently on these facts. It's just incredible as to how these things play out. If you're making this commute every day, you probably won't be covered because it's not special.
Yeah.
It's a daily commute.
Sure.
But if it's a one-time occurrence, then that could constitute a special mission. That you're covered. And now, are you covered when you walk out your doorstep before you get in your car? Probably not. But when you get in your car and you're backing your car up and somebody hits you when you're backing your car up, are you covered at that point in time? I don't know. if you're making that one-time special trip, So when do you become covered? That's always the question.
Okay, to caveat off of that, if on the way back, he stops at the outlet mall, and then while he's at the outlet mall, he trips and falls.
Yes, exactly. Yeah, and that would not be covered for the reasons that people have mentioned, which is deviation. Bottom line is when the court is looking at these cases, they're going to literally draw a line between point A and point B. And if let me tell you a case that is really kind of screwed up. There was a case, well, to finish this concept, if you point A and point B and you go to point C, then anything over here you're not covered. But once you get back on this line, you're going to be covered.
Well,
Okay. So
the outlets is right in line. It's in line with the stops.
yeah, you're not going to be covered still at that point in time. That's still a deviation.
Unless you stop to buy pins for your office.
Yes.
That's my story.
And that's your story. That's the story.
Just saying.
Yes, ma'am.
So, and I know this will come, but let's say, okay, I drove in this morning from Dallas. So when I'm back on the highway going back to Dallas, I'm now covered and they're workers' comp. What if I hit somebody and I'm
I hope you have really good insurance. Because
Yes.
we don't cover you, we have
Yeah.
covered non-owned.
Right,
For
exactly.
workers' comp.
That's going to fall under whatever employer's liability insurance policy they have at that point in time.
Right,
But it won't be a
but
workers'
it
comp.
won't
I mean, you
fall
will still cover as a workers' comp person, injured employee.
right.
Yeah.
But it would be a small liability,
If they
No.
have hired.
general liability.
No.
No, it's your liability.
Yeah.
And if we're sued, we're covered, but you're not.
Which car did you drive?
Right, right.
Did you drive your car company?
I receive a monthly,
But it's not their GL, it's their hired and non-owned.
Hired and unknown auto.
Yeah.
Well, it depends on what car you're in. You're in
Yeah.
your
If
personal
you're in
auto
a-
or their car.
yes, but what we've been told is that if we're on school business and we receive a regular monthly stipend for travel,
Yeah.
that then it would be ours.
Now we're getting into subdivision.
Wow.
No,
That's-
Huh.
No,
She receives the stipend, she covered.
doesn't matter. Hired on with physical damage.
One is secondary, the other
But it's her own
primary.
deal. It's her own personal.
Something like that.
Well, I don't know.
That's why
It depends
it's
on
on
policies or
You always
originally.
Own personal.
Yeah. And I'm not exactly sure. I would have to do my legal research about that, to be honest with you. But
But they're not gonna
your
cover
personal-
physical damage to your vehicle, you still have to cover that yourself.
Right.
Yes, you're right, correct.
But the person I picked.
Right, it'll be
Your
your institution's hired and non-owned auto policy will respond, assuming they have one.
See, I'm specifically told that by my employer.
The entity is covered, she is not covered.
I get X amount
Well, they're gonna go for
a
the
month,
entity because the entity
but
has the money.
if I hit somebody, that's on my insurance. That's
Yeah, right, exactly. Yes, sir.
Where can we go? Where can we go?
They don't decide to sue several times.
I don't even know if we
Might
can.
as well get it.
I mean, because like you said, every case is different. There's
Right.
all kinds of dynamics that come.
Exactly.
You know, I've got one I'm dealing with right now. Where can you go where it says, under this circumstances, it's this case law and it's covered? Under this particular circumstances, you know, whether it's to or from, course and scope, deviations, you know, this is not covered. Is there any,
Nope.
nothing?
Nope.
Other than go to your legal.
Yes.
And ask them.
Yeah, you,
And
I
hopefully they
mean,
know.
yeah, I mean, the cases are so different. When you look at appeals panel decisions, they will change depending on the facts of the case, so.
Dynamics though, where can you go where you say like, if you're driving your POV, but we're paying you mileage to go from point A to point B, and we'll do that for any employee, but you decide others are gonna carpool with you.
Okay.
They don't get paid, you get in a wreck, the employee driving the vehicle's covered, the other employees aren't. I mean,
And that may not necessarily be the
it
case.
may not be.
Yeah, it may not be the case. I'm just saying, because you have a company vehicle or because you're reimbursed, doesn't put you in the court scope of employment.
Right.
You still have to be further business first with the employer. You still have to meet the definition of course and scope. So for everybody in this room, because you have a company-owned car or because you're reimbursed for mileage, does not put you in the court scope of employment at that point in time. You still have to go through analysis of course and scope for sure. But I want to get to your question, ma'am. You raised your hand a while back. I'm
I was just
sorry.
actually hearkening back to the thing you began with, which was the outcome of these three guys in the car and the two cases and the one, and they both come out with completely different decisions. So did Texas Mutual end up paying the one guy who won and the other two who lost didn't get anything?
Well, to be honest with you, I don't know. Because what happened was the Court of Appeals, they reversed the summary judgments and they remanded it back to the court, to the trial court. It says summary judgment should not be granted. This needs to go to a jury trial. So I don't know what the jury verdict was on these three cases. So I don't know.
Both of them, the two and one,
Right.
both have to go back.
Exactly. Yes, sir. Exactly. All of it has to go back. Yes. I'm sorry, you brought that.
When you mentioned premises, can you clarify that when you said, when you step on your employer's premises,
Right.
that does not constitute the automobile they give you to drive?
Wait. What's
The
that?
premises, when you
Yeah.
step on your premises and you
Yeah.
slip and fall
Right.
at work,
Uh-huh.
just because you're in their automobile doesn't mean you're quote unquote on their premises.
Well, what I was saying in that regards is, so you said if they're in an employer's automobile at that point in time, yeah, you're obviously you're not covered necessarily at all. So first of all, but I think we're talking about two different concepts of being in a company-owned vehicle versus the access doctrine. I believe that's what we're talking about.
Okay.
So if you're in a company-owned car, for instance, police officers. Police officers are generally not in the course of employment 24/7, unlike whatever police
They'll
officers
argue.
generally believe. Huh?
They'll argue.
Yes, they will argue that, and I've had several police officer cases. But of course, if they're enforcing the law at the time they're hurt and they're off duty, then they are in the course scope of employment because the laws require that they always enforce the law. When they see something, an offense being committed. But just say, let's talk about you, sir. What's your name?
Michael.
Michael. Okay. So Michael, let's say you're in a company car. You're driving home for the night. You leave for work and you get in a car wreck. You're not going to get a course scope of employment. And if you're driving back to work from home in the morning, you get in a car wreck, you're not in a course scope of employment even though you're in a company car. Or if you're getting reimbursed mileage for whatever strange reason. But when you drive into that employer's parking lot, now if it's a parking lot that is shared by a lot of different businesses, and you slip and fall, generally you're not going to be in a course scope of employment because that parking lot is not controlled by your employer. But if you're in a parking lot that's controlled by your employer, and you know, we don't know what really control means because you know, employer's not out there, you know, with binoculars and then share, you know, everything's okay in the parking lot. There's no potholes and stuff like that. But generally, if it is controlled by the employer, you will be in the course scope of employment at that point in time. But as far as talking about deviation, there was a case that came down a while back that a person was going from, I think, from one business to another business, and you're always in the course scope of employment if you're in a car wreck. You know, if you stay on that straight line, there's no deviation. But this person saw somebody, I think a car had broken down, they went to help, and it was a Good Samaritan situation, and apparently they got run over. Yeah, and they found that that was deviation. And they were not in the course scope of employment. Once they got out of their car and they went to help that person, that took them out of the course scope of employment, even though they got run over.
Good Samaritan doesn't get
Good
a,
Samaritan
you
does.
don't get a Good Samaritan law or anything?
Nope, not in workers' comp.
Oh my God, your law is not nice.
Yeah. So, you know, they're real. I mean, they're really strict about, you know, what you're doing between point A and
So
point
they
B.
should have said they actually pulled over to use the restroom.
There you go. They could have done that. Yeah.
Gas station.
Yeah.
Stop at the gas station.
Yeah.
Well, you're putting gas in the car. Or you're running in to get a bag of chips, a cup of coffee. Come back out, fall over the aisle. Okay? Break your teeth. Want some soda?
That's a very good question. That's a very good question.
I would
Yeah.
say it normally is because it's considered normal comfort of life. You
Yeah.
allow your employees to have snacks at work, you allow them to go to the restroom,
Yeah.
allow them to take a smoke break. I've had to cover someone who fell having a smoke break for 20 minutes, was going on a break, while they're out in the park with their girlfriend.
Wow.
Walking, talking, not paying attention, she fell her wrist, I didn't realize.
Yeah. Yeah, those are real tricky. Like I said, I mean, it could turn you. Now let me first tell you, in those type of situations we're talking about, don't be afraid to deny the claim. You can always file a Appeal 1 denial. Now, whether or not you win at CCH is a different story than whether or not you have the right to deny the claim. So, and as when you deny a claim and you investigate the claim, you may get a lot more facts that may turn it, who knows, you know, good for you or bad for you, and you can you know, amend, supplement, or withdraw your Appeal 1 denial based on the additional information that you receive. So you just have to keep an open mind as these claims go through the process, for sure. So, but there was another an interesting situation that I ran into yesterday, and I did some research on it, and this is really fascinating to me. We learn something new every day. And I don't know if anybody's dealt with these type of situations, but there was a claimant that had a work injury and got an impairment rating, and it went to a CCH, and the hearing officer found that the impairment rating was 20% for this claimant, and the carrier did not pay the 20% for whatever. I have no idea why they didn't pay, but they didn't pay. The CCH decision order came down 2 years ago, and the claimant died February of this year, was never paid benefits, the impairment income benefits at all. The claimant had apparently been calling the carrier for the 2 years before they died, saying, "Hey, don't I get some money? Don't I get some money?" And the carrier never paid. See, I don't know the reason why. But the daughter, after the claimant died, the daughter called the carrier and says, "Hey, my mom died, and you know what's up? Where's the money?" So, here's the question to you guys: do y'all think that the daughter should get paid the impairment income benefits that was owed to her mother.
Yes.
To the mother.
Okay.
The estate.
To the estate as well.
The estate, not the daughter.
Yeah, to
I
the
would think the
estate.
person, the estate in trust or something. Do you
Right.
agree or no?
Yes, that's correct. And what is interesting about that, when I've done some research about that, the case law doesn't say that is automatically owed to the estate. But when you read the laws, it talks about that benefits that are that have accrued and that are due, that need to be paid. It says that the estate can go after that money. But what's interesting is that probably wouldn't apply just for permanent income benefits, because it could apply if the statute reads and is interpreted the way it's interpreted by these two cases back in 1995 and 1997. If temporary income benefits have accrued and should be paid, and they're not paid, then based on how this law is written, how it's interpreted, excuse me, then the state can go after TIBs also. Any benefits that have accrued and that have not been paid but should be paid and have been paid, that the state can go after all that stuff. It should never be paid directly to the daughter, for sure. Exactly, to the estate, because you can see the nightmare that will come out. You pay it to the daughter, then the other siblings are like, well, where's my money? You know, so it's got to be divvied up. If they're intestate without a will, then it's got to be divvied up based on the state testamentary laws, intestate distribution of property, as we have it here in Texas. So anyway, that's something to consider in y'all's cases. That if you have a situation like that, then it should go to the estate for sure.
Has the estate sued the carrier yet? Sounds
No.
like they got one hell of a lawsuit.
They have one. They got one heck of a and you know, I told the carrier, I said, well, my concern for you would be the violation that would come down, because one is you didn't pay on the decision and order. That was 2 years ago. 20%. Yeah, and you know, and two, you didn't pay on benefits that had accrued and were owed as well. So I mean, their interest is going to be huge, but the potential violation could be monstrous.
Think of the stress it caused her. Maybe it was the stress that
Yeah,
killed
the
her.
mental anguish.
I'm just saying.
Yes, and that would be tragic. Yeah, that would come down death claim. Yeah, or something like that for sure. So, okay. I see it's after 2 o'clock. I know y'all probably want a little bit of a break, whatever's going to happen. So I do have some other PowerPoint. Do you have a? Okay. I do have some other slides to go through, but we will be here for the rest of the afternoon.
You're on till 2:15.
Huh?
You're on till 2:15.
Oh, not to 2?
2:15.
2:15.
You have like 12 more minutes. Keep talking.
Oh, okay. Okay, all right. I thought I was getting booted out at 2.
No.
Oh. Okay.
That's fine.
Read it out
You know
loud.
what? You know you're a very Really?
All right, this is an interesting case. In this particular case, Simpkins was an employee. He fell at work on September 9, 2005. He died 7 days later. It was undisputed that the cause of death was a skull fracture from striking the floor at work. The jury found that he suffered a compensable injury that was the producing cause of his death. The carrier appealed, arguing that the evidence did not support the verdict. The carrier contended that a stroke, pulmonary embolism, or other pre-existing condition caused the fall. The court ruled in favor of Simpkins, deciding that the carrier, as the party with the burden of proof, did not conclusively establish that the fall was caused by a pre-existing condition. Now, what this case talked about was, the positional risk test, and there was a case, and it's called the Brax. Can't remember the name of the case, but This is, they refer to another case. And in this other case, a person had a, what's called a berry aneurysm to the brain, and the person died. And this other case, the person had the aneurysm, and because there was unnecessary pressure applied when the person, this is what the case says, when the person was defecating. And because of that, they died from an aneurysm, from defecation. And so they talked about, and this isn't the case. And so they talked about the positional risk factors in determining whether or not that there's enough proof to show that a person was in the course scope of employment. But what this case talked about a lot, the Simpkins case was, so what if, by the way, there was testimony at this case that the person was shaking and his eyes rolled to the back of his head and then he fell down. And this person had, I think they had high blood pressure and diabetes, high blood pressure, and a couple other artery diseases of life. So the question that they were trying to answer was, did these artery diseases of life cause this fall and cause this person to die? Now, the autopsy report and the death certificate said that the person died from a skull fracture. That the cause of death was not an embolism or a stroke or something else. It was a skull fracture. And bottom line, this case said that if a person falls, it could be idiopathic, which means you have no idea why they fell, or if it's an embolism or stroke, whatever. If the cause of the injury is an instrumentality of the workplace, then you accept that injury that was caused by the instrumentality of the workplace. Once this person fell and struck their skull and they developed a skull fracture which caused their death, the hitting the floor and having a skull fracture was the cause of death, and that became a work-related injury because the floor caused the death, not the embolism or the stroke or whatever the person may have
But
had.
isn't there also something that speaks to that if you hire them with that condition, you kind of bought it?
Yes. Well, there's that term that they talk about, whatever the term is. But yeah.
Well, they're not gonna disclose that.
Well, they're not.
Right.
They may not know.
They may not know.
No, you guarantee they're not.
Right.
I'm diabetic, come from a long line of people who died from heart attacks, and I'm hoping I'm gonna outlive my family history, but.
Oh, heart attack's easy, we deny that.
We actually have a heart attack and fall down some stairs. Survived a heart attack.
Yeah.
So they ended up paying.
Work we have to buy.
Yes, they ended up buying it. Yeah, they had to pay for the death benefits and the burial, that stuff. Yeah, absolutely.
Well, they're just lucky he died, because quadriplegic is much worse.
Yeah. So does anybody have any heart attack cases right now, by the way? No?
Ours are all denied.
Huh?
Does any heart attack actually become a case, or are most of them denied?
Yeah, most heart attacks are going to be denied, as they probably should, to be honest with you, based on how the appeals panel rules any type of cases, a heart attack cases.
Well, we know it's a heart attack, we just deny it.
Right, exactly.
You sometimes see some of the fire departments that are examples.
Okay.
They show that it's been, for 30 years they've been going in and out of burning buildings.
Right.
Lifetime of being compromised.
Exactly. Does anybody, who has police officers that work here? Police officers? Do you have any police officer cases right now? Anybody have anything going on like that? Okay. Just for you guys that have police officers, just real quickly, generally, the case law is going to find that if a person is doing an off-duty, if they have an extra employment, they're hurt, it's going to be covered. But there's some case law that has put liability on the extra employment employer as well, that will allow you or a police officer to go after the extra employer for workers' comp benefits, and not the city or the primary employer.
Even though the primary, in our shop, we actually have a sergeant that arranges for a lot of these extra duty things.
Just muddied it.
That's-
Yeah, I'm just saying there's case law out there that will allow, I mean, they're gonna be sure the police officer's protected by
Yeah,
somebody.
definitely.
So, but if the extra employer has workers' comp insurance,
Okay.
then they will allow the police officer to go after the extra employer. It would be kind of under the borrower serving doctrine almost to a certain extent, because they have control of the police officer, and if they're directing the police officer's duties at the time that they're hurt with the extra employer, and they got workers' comp benefits, they will allow them to go after them, and the extra employer would have to pay benefits, not the primary employer. So I'm just saying it's not automatic that you pay benefits to the police officer. So you won't, if you had a situation, you may want to consider that and reevaluate those types of situations, for sure.
We don't pay on extracurricular jobs, off-duty jobs.
Okay,
Unless they're affecting law enforcement.
Unless they all of a sudden have established that there's a crime being committed.
Right,
Take
right.
off in pursuit or something.
Right.
As soon as they institute
Right.
that, it's ours. But
Right.
otherwise than that, they go after the extracurricular employee.
mhm. Yeah, there's a one case that I found that a police officer was working at a construction site, and they were directing traffic, which is police activity, and they got run over. And normally they would always go back to the primary employer, you guys, but they found that the construction company was responsible for it in that particular case, because the construction company that hired them was controlling them, was told them where to go, and they were standing out there and they got hit. So I'm just saying, you may want to reevaluate the situation if you run into that in the future.
With somebody.
So, yeah, it's going to be you or them. Yeah, if they don't have workers' comp coverage, you're going to be liable for that automatically, basically. So,
Now, what happens if an officer's off duty representing the city at a function, say a golf game? And he's a salary guy anyways, and he gets injured at the golf game? Is that something that you can ask of the function?
if he's injured at a golf deal, well, that's going to become probably one of the off-duty recreational activity type situations analysis. If they're playing at a golf event, something of that nature.
Like a charitable police?
Yeah. More than likely, that's going to be covered because there's going to be a reasonable expectation of participation by the police officers, which is how the analysis is under the appeals bond cases. So, but more than likely, that would be in the course scope of employment.
Not that I had a guy fall out of a golf club, but that's.
Well,
We'll see.
is that what happened?
Well, I don't know. We'll see if I officially ever hear anything.
Yeah. Well, now, again, in my opinion, that's gonna delve into another whole new concept of possibly going to be deviation or something.
Yeah.
I mean, if a person is at a volunteer recreational event
Yeah.
and they get tanked and they can't stand and they fall over and they fall out of a golf cart or something like that, that's not going to be covered. I mean, well, one, you're going to have the defense of intoxication.
Yeah.
Two, you're going to have defense of probably deviation or something of that nature because it takes you into the course of scope, I believe, if you're, and let me just follow up with a concept, and this is the last point I'm going to make to you guys about these things. And we were talking about you driving on distance for, and if you're, this is the continuous coverage principle. Which is if you're going away on business for, let's say, a week or 2 days or a month or whatever, that generally under the continuous coverage principle, you're going to be covered much more often, than you would be if you're at home in your own city. So if you are going out to a restaurant and you're away for a week and you get hurt you slip and fall. If you're at home, you're not going to be covered because you're away from work, unless you're entertaining a client or something like that. But if you're away for on business and they send you off to something like that, you're more than likely going to be in the course scope of employment under the continuous coverage principle. But if you, a deviation, I mean, you can't deviate as well. So if you're out of city for a week and you go to the local nightclub and you get, you start taking 5 tequila shots and you get hammered, and you want to go back and start doing the Michael Jackson moonwalk, and you trip and fall over your feet, you fall flat on your face, that's going to be a deviation, and you're not going to be in the course of scope, even though you're away from your office because you're on a business trip, but you deviated at that point in time for sure. So anyway, I'm going to wrap it up with that. I think it's about 2:15. I appreciate coming to talk to you guys today. If you have any questions, let me know. Again, we got a ton of green pens. You may not remember my name, but you remember my pens. And
Remember, you're the tree hugger.
yes, exactly, I'm a tree hugger. So I appreciate it. Thank you very much.
Thank you.
Thank you.